In 2016, a Supreme Court judge asked the Maharashtra government, "Do you want a pound of flesh?" This was in relation to a case where the Maharashtra police had arrested a 90% disabled professor of Delhi University. A journalist in Kashmir was arrested and detained for an 18-month-old social media post. A website affiliated to Greta Thunberg, basically for environment protection, was charged by the government of India for threatening the sovereignty and integrity of the country. All of these absurd charges were made under the Unlawful Activities Prevention Act, popularly called the UAPA. Professor G. Saibaba, Masrat Zahra of Kashmir, and Fridays for Future, the website, are amongst the many who have seen the wrongs of UAPA. Recently, Umar Khalid was also charged under the Unlawful Activities Prevention Act without any solid evidence, and technically you don't need a warrant or any solid evidence to charge anyone under UAPA. However, to counter a draconian law, it is important to understand it first. So today, let's understand how India's most stringent preventive detention law works. My name is Shan Fosdar and you are watching the Upfront. Does the Indian Constitution allow for such a draconian law? And if yes, why? This is the most common and the most obvious question in any discussion on UAPA. Well, UAPA comes in a category of law which we call preventive detention laws. Preventive detention means to detain a person on the basis of suspicion to prevent him or her from doing anything which might be hazardous to the public or illegal in near future. Article 22 of the Indian Constitution provides for preventive detention. Clauses 4, 5, 6 and 7 of Article 22 lay down instructions for the government to follow when and while making a preventive detention law. India has seen many preventive detention laws and UAPA is not the only one. It is an interesting fact to note from history that whenever a new government has come to power, it has made a new preventive detention law. Vallabhbhai Patel brought in independent India's first preventive detention law in 1950. Following which, Indira Gandhi brought in the Maintenance of Internal Security Act MISA and the National Security Act NSA. Then Rajiv Gandhi went ahead and brought in TADA, Terrorism and Disruptive Activities Prevention Act. Following which, and finally, Atal Bihari Vajpayee brought in POTA, Prevention of Terrorism Act. When the UPA government came to power in 2004, it did not bring in a new law, but it amended the UAPA of 1967 twice to make it very stringent. And when the BJP came to power in 2014 and 2019 respectively, in 2019 it amended UAPA again to make it the most stringent preventive detention law India has ever had. To understand why our forefathers and foremothers put such a draconian provision in our constitution, it is important to understand the condition of India during and after independence. Gandhiji had been shot dead, the country was wrecked with communal violence, the South was fighting for English to stay as the official language, the states were fighting for territory and division on linguistic lines, and above all this, Kashmir, Punjab and the entirety of Northeast was burning. In such dire times, it was important to preserve and protect the newly found independence which India had got, and hence internal security was given more importance than personal liberty. In an interesting instance, after tabling the Preventive Detention Law of 1950, Vallabhbhai Patel stated that he could not sleep for days before and after tabling this bill. Article 22 was the need of the hour then when the constitution was being drafted. There are two questions ahead of us now. Is it still the need of the hour? And has it been used in a just, fair and reasonable manner? Tell us what you think in the comment section below. UAPA, it is not a 1 or 2 page law. It is divided into 7 chapters, 53 sections, 4 schedules and is spread over 20 pages. It is a huge law. But understanding a few provisions of UAPA can help us understand why this law is so draconian. At the onset, it is important to understand that all offences under UAPA are cognizable offences under section 14 and 43d1 of this act. This means that if you are charged under UAPA, you can be arrested by the police without a warrant. All offences which do not require a warrant are called cognizable offences. This provision has been used in a very unjust manner by the police in many cases. If I give you an example, 18 students in 2008 were arrested by the police for having what they called jihadi literature. In the court, it was found that on investigation that this jihadi literature were nothing but copies of Quran. This was the famous Hooghly conspiracy case. Further, you can be charged under UAPA for two things: unlawful activity and terrorist act. Section 2O of this act defines unlawful activity, and this definition is so vague and so wide that literally reading the Communist Manifesto can be termed as an unlawful activity. This section defines unlawful act as anything which causes or intends to cause disaffection against India. Well, what is disaffection in legal terms? Anything which the government wants it to be. This was proved in the case of Saibaba, where this 90% disabled professor of Delhi University was arrested by the police for having Maoist sympathies and engaging in anti-national activities. Section 13 of this act says that anyone who assists in unlawful activity is also to be punished. But it does not define what assist means. Hence, if a journalist is doing his or her job of covering a protest, he or she can be termed as assisting in the unlawful activity. This actually happened in Kashmir in the case of Masrat Zahra. I will put the link in the description of the stories of Masrat Zahra and Professor Saibaba. Please do have a look. Section 15 of this act deals with terrorist act, and it should be written down that spreading communal violence or doing cyber attacks are not terrorist acts under this law. Finally, getting bail under this act is very difficult, almost impossible, thanks to section 43d5 of this act. This provision has been used continuously for preventing people from getting bail. An example of this is the case of KK Shahina. KK Shahina was reporting the Bangalore blasts when she was asked to leave by the police. When she did not leave, she was charged with intimidation of witnesses. Then when she applied for anticipatory bail, she was pressed under UAPA charges and hence prevented from getting bail. A law, no matter how draconian, is as good as nothing unless used by the government. Here is an interesting fact. NCRB before 2014 did not have a special column dedicated for crimes under UAPA in its annual crime report. Other reports show that before 2014, UAPA was there just for namesake and was not used all that much by the government. However, something changed in 2014. NCRB introduced a special column dedicated to crimes under UAPA in the SSL crimes, and the use of UAPA practically blasted. The numbers reflect this. The total number of cases filed under the UAPA rose from 976 in 2014 to 897 in 2015, 922 in 2016, 901 in 2017 and 1182 in 2018. According to a report by The Hindu, 3,974 arrests were made under UAPA in the years 2016, 2017 and 2018. The rampant use of UAPA has predominantly been on journalists, activists and anyone dissenting with the government. And this shows us how the disaffection against India clause can be twisted and turned to suit personal and political motives. To measure the effectiveness of a law, it is imperative to look at two numbers, two figures: the conviction rate and the pendency rate. The conviction rate is the percentage of suspects who are found guilty in the court of law. If we look at the conviction rate of UAPA given by NCRB, it is found that in 2014 the conviction rate of UAPA was 27.3, In 2015 it was 14.5. In 2016 it was 33.3. In 2017 it was 49.3. And in 2018 it was 27.2. This means that less than 30 out of the 100 people charged under UAPA are actually found guilty, and the rest 70 are acquitted or innocent. This shows us that UAPA has been predominantly used for political and personal motives and not for the purpose of actual convictions, which then leads us to the conclusion that UAPA has been used by the government for its political motives, and this shows us the ill intentions and the intolerance of this government. The pendency rate is defined as the number of cases pending in court. If we look at the pendency rate of UAPA provided by NCRB, in 2014 it was 97.4, in 2015 it was 94.2, in 2016 it was 97.8, in 2017 it was 95.9, and in 2018 it was 93.4. This essentially means that 95 out of the 100 cases charged under UAPA are left pending in the court of law in that very year. And this means that 95 out of the 100 people, most of whom are innocent, as we saw from the conviction rate, still have to spend years of their lives in India's prisons. And India's prisons are the worst place you ever want to be in. A man named Arun Ferreira was charged under UAPA in 2007 for a mere suspicion of being a Naxalite. He was eventually acquitted, but he had to spend 4 of the worst years of his life in jail. After getting out, this man wrote a book called The Colors of the Cage, a prison memoir. In this book, he describes how horribly he was treated in the jail in the 4 years, and it's a must read. I'll put a link of that book in the description. Please do have a read. Hence, with a low conviction rate and a high pendency rate, UAPA has essentially become a tool for the government, which the government is using indiscriminately to suppress dissent. UAPA is a law which saw huge social outcry after the 2019 amendments, but it should be noted that even before 2019, this law was being used rampantly by the government. The 2004 and 2008 amendments to the UAPA by the UPA government made this law very draconian and very stringent, and the Congress is to blame for it. UAPA became a loaded gun after 2008. And when the BJP came to power in 2014, it simply fired this gun and has ever since been firing it indiscriminately. However, the government needs to understand that suppressing dissent will only lead to more dissent, and if only the Prime Minister heeded his own words on democracy and criticism, an old poet by the name of Varavara Rao wouldn't have to spend months in jail covered in his own urine. If there is no dissent, there shall be no democracy. And if at all the government is seeing this video, I would like them to hear the Prime Minister's words on democracy and dissent again.
लोकतंत्र में अगर विरोध नहीं होता है, आलोचना नहीं होती है, तो फिर वो लोकतंत्र कैसे हो सकता है जी? और मैं मानता हूं, और ये मेरा कन्विक्शन है, ये सिर्फ शब्द नहीं है, मैं मानता हूं डेमोक्रेसी की अगर उत्तम से उत्तम कोई ब्यूटी है तो वो क्रिटिसिज्म है। मैं मानता हूं मोदी सरकार की भरपूर आलोचना होनी चाहिए, हर प्रकार से आलोचना होनी चाहिए। क्रिटिसिज्म से ही तब करके डेमोक्रेसी पनपती है।
If you like this video and if you like the work that we are doing, please do help us by liking this video by giving it a big fat thumbs up and subscribing to our YouTube channel. Also press the bell icon just beside the subscribe button so that you get regular update on whenever we upload a new video. Thank you so much.